Swayam Prabha. Digital India. Educated India.
Hello students, this is the time to learn some more lessons, and you all remember that we have been trying to understand the basic schools of jurisprudence. In the last lectures, we were trying to explore the different schools of jurisprudence in the Western world. What happened in our part of the world? Whether we did not develop any school of jurisprudence, whether there was no jurisprudence in this part of the world, and now today we are trying to explore that part which developed in this region of the world, in our country, that was Bharat, and what was the Bhartiya jurisprudence. That is the topic of today's lecture. I hope you are all well and in a mood to understand the Bhartiya jurisprudence, ancient Bhartiya jurisprudence. We have to understand in this lecture the oldest law which was given by one of the famous philosopher of that time. His name was Manu, and he had written a great book that was called Manusmriti. What were the thoughts of Manu regarding marriage, on the role of women, on the different ashrams of life, about the powers and duties of sovereign, and about the various disputes, its classification and its resolution. He also discussed issues like marriage, succession and inheritance rules. Then he was talking about a system of society that was based upon Varna, and then he was reflecting upon the penances and the punishments. He also discussed in those times the rules of jus in bello, those are the rules of warfare, and he also discussed about how to settle a dispute peacefully. Students, you can just imagine that this Manusmriti was written, many scholars they differ on the view exact origin of this law or this Manusmriti, but then many scholars they agree that at least 2000 years back this book was written, or if there was no such kind of possibility of writing the book, this might have been orally transmitted from one sage to another. So in those times, 2000 years back, when this law, and in those times it was called, based upon, because these were the things which were based upon Smriti. So Smriti means how do you remember oral traditions, and therefore this is called Smriti as told by the sage Manu, and therefore it has been called Manusmriti as remembered through the various different succeeding generations. So in this lecture we will try to understand, although this is very old text, it might have lost importance in many aspects, but let us try to understand that what are those aspects on which 2000 years back, when the civilization, the human civilization was starting, we must try to understand the word civilization. Civilization is not that a person can do whatever he likes or she likes, but civilized means that we have a society where the disputes can be resolved peacefully, and we have the society where people are enjoying their life in peace. And how this can be possible if there is a state, and then the state should be also having controlled by the government, and the government must be good. So, these are the prerequisites, and therefore, in those times about human civilization 2000 years back, the human civilization when that started in this part of the world, then this kind of lecture, this kind of knowledge was transmitted by the great sage Manu in such times. We will look at the different chapters which talk about different issues. There are 12 chapters in this book which has been now codified. It has been published by many publishers. English translation is also available. In 18th century, late 18th century, the first English translation was done by a Britisher, because he discovered that there is no translation of this law in any other language. So, in those times he started translating it, and he wanted to understand, and he wanted to make this law available to other parts of the world. So, in the late 18th century, when it was translated into English by the Britisher and Western world, what happened that this was also known to the other parts of the world. In this new version, this Smriti had 12 chapters. 6 chapters are relevant for a student of law who wants to understand jurisprudence, and those chapters are chapters 3 and then 7, 8, 9, 10 and 12. So, these chapters, if you look, so how many chapters are important? Out of 12, half of the chapters. Out of 12 chapters, if 6 chapters you happen to read sometimes, although this text is not available everywhere, because you will have to understand little bit of Sanskrit also, because originally the real meaning comes from Sanskrit, and Sanskrit is the oldest, one of the oldest languages of the world. So, 6 chapters if you look at, let us have some examples. Like chapter 3 talks about different types of marriages. Chapter 7 talks about duties of sovereign or the king. Chapter 8 talks about disputes and its resolution in a peaceful way. Chapter 9 talks about rights and duties of males and females in society. Then it also takes up the issue of inheritance and succession. Look, these are the things where civilized society wants to ponder over. Inheritance, what will be the process of inheritance? If your father leaves some property, what will happen to that property, whether a son or daughter can take the property, succession, etc. So, these are the issues which had arisen 2000 years back also, and then when some norm, some rule was developed, only then human civilization could claim that they had started behaving in a civilized way. Next chapter was about a social system which was to be established, and that was Varna system, and next chapter is on penances or punishments. So, in those times also the requirement of punishment, who could give punishment? You have all understood now the different schools of Western jurisprudence, in which the positive school, they were talking about the importance of sanction. Likewise, even 2000 years back, Manu had talked about the importance of punishments, importance of penances. We will discuss all these issues today, and we will try to understand how it has relevance today. Moving on to the first important topic of understanding relating to jurisprudence was the understanding on marriage. 2000 years back, Manu understood the importance of marriage, because only after marriage a society can move in a civilized way. Otherwise, if there would be no institutionalized marriage system, then persons can do or marry or have relationship and then skip or leave that person. So, in those times he said that no, marriage has to be institutionalized. There should be some rule on marriage. What are the legalized forms of marriage? What are not the good types of marriage? So, on these issues he had certain understandings and he tried to make it known to his disciples. And what he said, prohibition of subpoenaed marriages. Now, subpoenaed marriage is still relevant in the Hindus, amongst the Hindus, as the new law on Hindu marriages, which are contained in the Hindu Marriage Act of 1955, there also this rule of subpoenaed marriage is still there. 2000 years back, this kind of discussion on subpoenaed marriage, that was started by Manu, and he said subpoenaed marriage should be prohibited. He did not say that subpoenaed marriage is allowed. Subpoenaed means cousin marriage. Simply it is like someone wants to marry a cousin, can he marry? Can she marry? In those times he said that no, this is prohibited. Such marriages are prohibited. In a family you can't marry with your cousin. So, this will be destructive, this will not be good for society. And he also prohibited relations, marriage among prohibited relations. So, in prohibited relations, even today in section 5 of Hindu Marriage Act, we have this prohibition on prohibited relationship. Section 5 says that prohibited relationship marriage is not legal, it is void. So, 2000 years back, you can just imagine that prohibited relationship, those were discussed, and how much up in the mother side, how much up in the relationship in the father side, those things were discussed, but because that was 2000 years back, so now it is not there. In those times Manu said 7 generations up from mother side. This is about the prohibited relationship and must be different from father's gotra. So, gotra is the word which is used for, you are coming from which sage. So, you are coming from a particular sage. If you are a descendant, then your gotra will be like that. So, prohibition of the father's gotra, prohibition of marriage from the father's gotra, and then you have to go up to 7 generations from the mother side. That was the kind of prohibition of marriage in those times. But still the important thing is that in our country, in Bharat, the jurisprudence on marriage, that was laid down, the start of science of law in our country, that was laid down 2000 years back when Manu said that there should be prohibition of subpoenas and prohibited relationship. He further goes on and he says about rules before marriage. You see that everyone wants to marry a girl who will be beautiful, but then not only beautiful, but he did not say anything about beautiful, but what he said that there must be some basic things, that girl should not have piles. Piles may be very difficult. In those times there was no operation for the piles, so that might degenerate and it would be very difficult. Then girls having TB, tuberculosis. So, in those times tuberculosis was also not could not be treated properly. So, it was how can a family run if a girl will have TB, girl having leprosy. So, these diseases, you can also learn about diseases which were there. Leprosy has been there since those times. Girl having epilepsy, fit. If a girl is a victim of such disease of epilepsy, this is a mental disorder. Girl having no brother, this was also one of the rule which was laid down. Girl having no knowledge of her father. So, if a girl wants to marry, but then she does not know about her father, it will be difficult. These were the rules which were laid down before marriage. Now, you will ask the question whether this was the rule for the girls only or also for the boys. Now, the tradition of this oral tradition of knowledge which is coming from those times, it says that these rules were only for the girls, but the boys perhaps also had to follow these rules. If a boy had leprosy, then boy could not marry a girl who was free from any disease. But then it might be, because it is not written in Manusmriti, so you may say that this was a kind of discriminatory rule if it was only applicable upon the girls. Then Manu said that marriage was allowed for the different varna system. So, how one varna could marry other varna, that was also laid down. Now, we will talk about varna system and what was the meaning of that in just short span of time, but here I would say that he said that Brahmans can marry with any other varnas, Kshatriyas with only Kshatriyas, and Kshatriyas can also marry with Vaishyas and Shudras, and Vaishyas can marry with Vaishyas and Shudras, but Shudras could marry only with Shudras. This is given in chapter 3, 12th verse. Now, why was this rule? There may be many reasons. Was that society discriminatory in nature? Was that society following a rule based upon the person's birth, or something was different? No one has certainty to say about it, but we will little bit discuss these things. But here I will say that what Manu said, that one who is belonging to the highest varna can marry any other varnas, girl from any other varnas, but likewise going below he was saying that no restrictions on marriages. And further he was saying that marriage was of 8 types. In those times, it meant that people could have married in different ways, different types of marriages were prevailing. Now, you might be looking at marriages and you would be bored of only looking at one kind of marriage, that bridegroom rides the ghori and then goes to the bride's home. So, this is the kind of, but then in those times there were 8 types of marriage, and first was Brahma, other was Daiv, third was Arsh, fourth was Prajapatya, fifth was Asuri, sixth was Gandharv, seventh was Rakshasa, and eighth was Paishach. Now, these were the different types of marriages. Paishach marriage, you see, you might have heard about Pishach. So, such kind of marrying, you could have heard some stories that some person or bridegroom, he goes and forcibly takes away the girl. So, these were the kind of things which were prevailing in those times also, and he had said that such possibilities are there, and he categorized different types of marriages into 8 types. You might have heard about Gandharva marriage also, when in Gandharva marriage, the marriage is based upon the mutual consent of the parties, that if both the parties are willing, they can marry. So, we say it love marriage now. In those times it was called Gandharv marriage. So, on all these marriages, different types of marriages, Manu tried to say something. He said that marriages can be classified into 8 categories. But then the comment also comes, and that comment is that offsprings from Rakshasa and Paisach marriages do not possess good qualities. Now, he might have given this opinion maybe because of his own understanding of the different Varna system. He might have said that if there is offspring from Rakshasa, then their behavior might also become like that. But again, these are not the hard and fast rules which can be there in the current times. In today's times, we can't say that offspring from a person who is born in a different small or whose father married in this way, then the son or daughter will be like that. So, we can't say this today, but in those times maybe that because of the very slow progress of the society, that he was saying that these offsprings, they do not possess good qualities. But on marriage, one thing that he said that still prevails today is Stridhan. What about Stridhan? He said Stridhan remains with wife even after the death of husband, even after the desertion by the husband. So, that is the law even today, that Stridhan is always possessed by the woman who is married. So, this is the exclusive property of the married woman in today's times also, and that is incorporated, that is recognized by the Hindu Marriage Act also. So, students, we have seen that what were the basic things which were told by Manu in those times. Now, he also said, he also commented upon the role of women in the society. And you might have heard this verse, which is also there in chapter 3. The 56th verse says that Yatra naryastu pujyante ramante tatra devata yatrai tastu na pujyante sarva astatra falah. Means God has a place where women are respected, and where the women are not respected, where women are not treated well, then there will be destruction. Family will be disintegrated, and this was a great comment in those times, and it was commendable that in those times he said that the role of women, the treatment of women, because it is very important to treat our women respectfully. Without that, the family cannot prosper, the family cannot have peace, because if you will not treat your women well, the family will not be peaceful, and you cannot live the sons and daughters or the relationship which are there, they cannot live well. So, Manu thought that if women will not be treated well, what will happen? And therefore, he laid this rule that treat women respectfully. Yatra naryastu pujyante ramante tatra devata, where the God will be residing. And where does the God reside? Where do you put your God? When you want to worship the God you like, you put it in the best place of your house. You want that there I will find peace. So, there if you want peace in your family, if you want peace in the society, then women should be also treated well. That was the rule which was laid down 2000 years back. Further, he talked about the different phases of life, and he gave the term ashramas. Ashramas of life, we say ashram. So, in Sanskrit it is called as ashram, ashrams of life. there were 4 ashrams of life. And what he says, first is Brahmacharya, second is Grihasth, third is Vanaprastha, and the fourth is Sannyas. These were the 4 stages of life. Ashram means stage of life. The first stage is Brahmacharya, then comes Grihasth ashram, third is Vanaprastha ashram, and the last is Sannyas ashram. Now he says that Grihasth ashram is the pivot of all 3 ashrams, and if Grihasth ashram will not be there, then other ashrams will not have relevance. Brahmacharya ashram, Vanaprastham, these will have no relevance if Grihasth. So he wanted to protect the Grihasth ashram, and therefore he wanted to say something about Grihasth ashram. He said a Grihasth should perform 5 yajnas every day. Yajna means you do some kind of sankalp, what you say, you take a vow. Yajna, you want to say something every day. In every day he says 5 yajnas, means every day you say 5 things and you want to do it. That is the meaning of doing yajna. You want to do yajna means that till this fire will be there in the Havan Kund, you will think about it, you will try to do that. He says that 5 times yajna. One is Brahma yajna, reading and propagating Vedic knowledge, that is called Brahma yajna. Pitri yajna, second is Pitri yajna, reading and trying to understand about your forefathers and mothers. And then Deva yajna, Deva yajna means knowing about your gods and goddesses. Bhut yajna and Manushya yajna. Manushya yajna means how do you treat your guests. Atithi, teaching how to treat your guests, that is also very important. So what he says that 5 yajnas every Grihasthashram should do, and what he says that when Brahmachari comes, a person who is following the first stage Brahmacharya, what he says, when a Brahmachari comes, every Grihasth should give alms, and he further says that Manushya yajna is important, you have to treat your guest well. He also said Atithi Devo Bhava. Further, he talked about extramarital relationship in those times. It meant that in those times also extramarital relationship, those might have been there, and he said it is prohibited. He did not allow any extramarital relation, so that there will be a society which will be, according to him, this will be a much better society if there will be no place for extramarital relationship. He said offsprings from extramarital relationship will not be allowed in social gatherings. Meant that if there would be extramarital relationship and if there would be some child born, then that child will be socially boycotted. So people could know that what will be the result of such relationship. So in those times it was not allowed, and he said that even not allowed, but even the son or daughter, they will face consequences if that happens. Finally, he says that ancestors should be respected and worshipped every day, and especially on Amavasya day. You see that this was the kind of respectful society where he was trying to say, he was trying to inculcate in the life of every person that how to treat, even though your parents might have been dead, your grandparents might have been dead, but still they should be worshipped, they should be given respect, and especially one day in a whole month. Amavasya comes in 1 month of Hindu calendar, Hindu month, and Amavasya is coming. So whenever Amavasya comes, what will happen, because it depends upon the movement of the moon. So, Amavasya then will come. Now, we will further see what are the powers and duties of sovereign or the king, because I told you that to make a civilized society, the state should also be there. That was the premise on which Manu wanted to tell that the law cannot function without having the state. So, this was the prerequisite. He said that if there is a state, then there is a king, and when there is a king, then what will happen? That you have to lay down the powers and duties of the king. Chapter 7 of this book contains different rules about the powers and duties of the sovereign. He says, Sarvasyasya yatha nyayam kartavyam parirakshanam. What does it mean? This is the second verse of the 7th chapter. He says, king has the first duty to protect the subjects with justice. Now, this was a very important duty. He also laid down duties for the king. He does not say that once you become a king, you forget your subjects. He says that the duty starts from that time. What does he say? King has the duty to protect the subjects with justice. That was a great challenge. Not only protection, but protection of the subjects with justice. Now, that was a great challenge which was given to the kings. The king should not sleep until they will protect the subjects, and not only that, they should protect the subjects with justice. He says that the role of the king in the society, the role of the king in the state is very important, because king is divine, and he gives a very high status in the society to the kings, when he says that the king is a divine person, because when he becomes or she becomes king, it means that there is something which is very special, and then he gives the divinity status to the king. But still he says that that will not be really functioning if the king will not have the duty to protect the subjects with justice. And he says that if there is no king, what will happen? There will be anarchy, there will be disorder in the whole state. So, the importance of the king he tried to underline. But then I told you that he said that there is a duty also. Further he says, what is the power? The power of the king is to inflict dand, to inflict punishment, as we have learnt in the positivist school of jurisprudence, where the positivist school, especially John Austin, said about the importance of sanction, the importance of punishment. Likewise, in those times he said that king had the power to inflict punishments. And he says, due to the fear of sanction by the sovereign, living being do their duties. You remember the slide or the lecture when we discussed about John Austin? John Austin was saying that it is the fear which compels the subjects or the political inferior persons to observe their duties, to follow the commands. And here also in a different way, here there was no such command which were issued by the political superior. So, we will try to understand it in a different time, but what I was telling you, that in chapter 7 verses 15 to 18, what is written, that due to the fear of sanction by the sovereign, living being do their duties. So, this was because of fear, this was because of the fear of dand, this was because of the fear of punishment, that people would observe their duties. But at the same time, giving power in the hands of the king to inflict punishment, what Manu further says, that sovereign has the duty to inflict punishment appropriately. It will not be misappropriately. It will not be arbitrarily, but the punishment will be meted out appropriately and with full wisdom. It will not be without wisdom. A king is presumed to be wise. So, decisions on punishment, that should be taken with full wisdom. He also adds the word full wisdom. It is not simply wisdom, but you have to give due time, you have to give due consideration to each and every aspect of the act in question, and then only the punishment can be given. If power of punishment which is granted to the king, if that power is used arbitrarily, then he gives a warning. And what does he say? That king will lose his power. Sovereignty will be lost. If the punishment is not given appropriately and not given with full wisdom, then what will happen? He says, he cautions the king that you will lose your kingdom because there will be injustice. That is the jurisprudence which was laid down, that even the powerful, most powerful person of the state, who was the king, that person should also do justice. That person should also be inflicting the punishment wisely. If that is not there, then the king will lose their kingdom. Then he says that mantri, importance of the secretaries, the importance of ministers. He says, wise friends of sovereign and a council of good people can be used to decide punishment. So, the importance of ministers, the importance in those times, there were no judges as such, but those people who could know that what are the rules to govern the society. So, those persons, they were considered wise, and he said, wise friends of either the sovereign or a council of good persons, they can be used to decide punishments. And he further says that king should be not an MBA, which may be there in our times. King cannot be maybe a MBBS or MD or BTech, but what he said, that king must be well versed in Ved and the Shastric knowledge. And especially he said that king must be knowing at least 4 strategies. One was the Sama, Sam means that very peacefully, and then Dam means you can give price, you can buy something for a price, Dand, punishment, and then Bhed meant that you create some kind of difference of opinion and then you use it for your own benefit. So, Bhed. So, he says that even when sovereign does not know many technicalities of other things, but the king must know these 4 important things, that was Sam, Dam, Dand and Bhed. And then he says that sovereign had also the power to maintain order amongst the different Varna system. And finally, he says that sovereign has the power to impose taxes, and he not only said that king had the power to impose taxes, but he also placed a limit, the maximum limit of imposition of tax. Unlike current times, when the tax rate, you might consider that the tax rates are very high. In those times, he also said that tax rate can be as high as 16% maximum, but he said that not beyond 16%. 16% means almost 1/6 of your earnings. So, if you earn 100 rupees, then you have to give in tax how much rupees? So, 1/6 means that you will have to give this much of around 16% of the tax to the government. So, you might have seen in this slide that how much were the powers which were given to the kings. Now, we will move on to see that he talked about disputes and how many types of disputes are there and how those disputes could be resolved. Now, that I told you in the first instance itself, that the disputes, if in a society, if disputes are resolved peacefully, if there is a mechanism for dispute resolution, then that society is considered to be a civilized society. So, this was also the time 2000 years back, he said that disputes can be of 18 types. You see, in those times it might have been a scholarly exercise to classify disputes into different types. He said that not repaying the loan, he just gives some examples. He says not repaying the loan, dispute regarding inherited property, then there may be dispute about seller, maybe that seller is there, but he does not have the title. Then partnership dispute, in those times there were partnerships to do business, so there may be dispute. You just imagine that, in those times also such disputes could have arisen, and therefore he might have classified it. Revoking a gift, gift was given, but then the person who gave the gift revokes it, then there may be a dispute. Non-payment of salary to employees, in those times also people could engage the employees and did not give salary, so there will be a dispute. Dispute relating to promissory notes, what you can learn now, promissory notes is a kind of negotiable instruments. So, hundis you might have heard. So, disputes relating to promissory notes. Then seller buyer, in those times also there was not, it was not that there was no selling and buying activities. So, seller and buyer dispute was also there. Disputes relating to abusive language, even today whenever someone abuses you, you get hurt and you try to have a dispute with that person. Violence, hurt, grievous hurt, snatching, robbery, theft, taking another's wife, taking another's girl, abducting, kidnapping, distribution of property and gambling disputes. You see that now we have the Bhartiya Nagarik Suraksha Sanhita and Bhartiya Nyaya Sanhita also, but you see that in those times so many disputes, those were classified and that those were also discussed. What he says, that the basic canon of dispute resolution is that adharma should never prevail over dharma. You might have heard today's teachings in the law, in the jurisprudence, that thousands of culprits, they can be not punished, but let there not be punishment to a person who did not commit any crime. He should not be or she should not be punished. Likewise, such kind of rule was prescribed in those times. He said adharma should never prevail over dharma. Dharmaiva hatohanti dharmo rakshati rakshata tasmat dharmo na hantabhyo ma nodhmati mahito avdhit. Meaning, whoever destroys dharma, dharma destroys them. Whoever protects dharma, dharma protects him. So, that was the time when he wanted to say that what is dharma? Dharma means right path, and what is adharma? Adharma means wrong path. What was the right path? Which was the path which was given in the law books, and what was adharma? Adharma was not regulated, adharma there was no rule on it, and therefore that should not be allowed. What he says, that there is a dharma for sovereign, dharma for varna, dharma for janpad, dharma for sreni. Sreni meant that association of the people who were engaged in trade and they were having offices in a market. So, if they were associated, they formed an association, a group that was called Shreni and Kul. So, he said that there was dharma for such people, such different types of people also. And then he says that fact has to be discovered. It is not that when the dispute comes to the king's court or the minister's court or to the friends of council of ministers, then those people, they should not try to investigate the fact of the dispute. Even today, you might know that the Evidence Act very clearly lays down this rule that discovery of fact is essential to further proceed in a case. In those times also, he said that discovery of fact related to the dispute is very important. That was given in chapter 8 verse 44. And while deciding disputes, he further gives some important things, that evidence is necessary. The first thing that he said, that try to know the fact of the case, and that would be based upon the evidence. But next he says that there should be some oral evidence, there should be documentary evidence, and the importance of witnesses. Now, all these things are there in today's evidence law. So, in those times, the jurisprudence which was prevailing, that was also caring for these procedural things. He not only laid substantive rule, but he said that there should be some procedure also, that who can be the witness, and then what would be the importance of oral evidence, and what can be the importance of documentary evidence. Further, once you have understood the dispute resolution and what were the rules of dispute resolution, he also gave certain rules on inheritance and succession and some more rules on marriage that we have already seen. He said that the age of marriage, you might not agree in today's times, because in today's times the minimum age prescribed for girl to marry is 18 and for the men is 21, but in those times 2000 years back, he said that the maximum age, he did not say minimum, but he was talking about maximum. He said the maximum age to marry for a girl is 16 years, and exception was that bridegroom should not be gunaheen. That meant that a girl could be excused to marry if she found the bridegroom without having any qualities. Usme koi gun nahi. There was no skill, there was no good virtue in the bridegroom. The girl could refuse to marry. So, the age of marriage was prescribed, but he also laid down the exception. Next was that suppose marriage takes place, and marriage takes place because you want to run the family, you want to run the society smoothly. Now, but if there will be no offspring, if there will be no child after marriage, then what will happen? Then that will be a great challenge in the whole institution of marriage. So, then he says that extramarital sex, that was allowed. Otherwise, he was saying initially, you might have seen that he said extramarital sex is not allowed, but for the purpose of getting child, what he says that this was called niyog. Niyog meant that only to get the child you are allowed to go for extramarital sex. And then he says that even then, if you do not get child, then only adoption will be allowed. So, chapter 9, 62nd verse, that talks about this kind of possibility. Further, he says that you cannot desert your wife. That was the rule. But exceptions were given. He says that there were grounds for deserting the wife, like when the wife was ailing, when she was condemned, when she had a defect, when she went to a foreign country, that is peculiar, and then she was in trade and then having grudges with the husband. So, if these things are there, then you could have deserted your wife, but these are, some of these are very difficult to understand today. He said that second marriage is only allowed. Normally he prescribed for one marriage only, but second marriage was allowed only when wife becomes a drunkard. That drunkenness problem was also there in those times. And bad conduct, if the wife had bad conduct, if the wife could go against husband, that was a little bit peculiar, because wives, they normally go against husband, but that is how he said that then second marriage was allowed. Perhaps that may be an aberration. And about inheritance and succession, what he said, that eldest son is the inheritor of father's property. And if there is a dispute, he knew that even prescribing such rule, even then there might be possibility of dispute. So, what he says, if there is a dispute, father's property would be equally divided amongst all sons. So, this was very important in those times, so that there would be less possibility of dispute, that how the inheritance will be smooth. He says that a state of childless Brahmans should be distributed amongst Brahmans, not to the state. So, you see nowadays the rule is different, that suppose if there is no claimant, the property, the estate, that will vest in the state. But in those times this was little bit difficult for modern society, that suppose if property is not claimed by someone, then it will revert back to the Brahmans. And further he says that although women have exclusive right to Stridhan, but if child is there, then child can have right over the Stridhan. So, suppose if a woman bears child, then child can have right to the Stridhan. Further he says that successor of father's property cannot be impotent. So, if the successor becomes impotent, then on that ground you can challenge the succession. And blind also, blind could not be right successor, deaf, crazy, dumb. So, deaf and dumb, blind, impotent, all these categories of successor, they could not inherit the father's property. If a son is childless, then his father can inherit property. Look, so many rules were there, so many rules were prescribed during those times relating to marriage, inheritance and succession rules. Look, this was the kind of jurisprudence which was laid down for the members of the society. Now, there is a lot of controversy over the Varna system, which was mentioned in chapter 9. He said Varna systems should be adhered to, but then was it a rule promoting inequality? The answer is yes. Varna system promoted inequality in those times. This jurisprudence which he laid down in 2000 years back, this will not be the correct proposition today. There should be no Varna system, and our constitution has prohibited any role of untouchability. If you practice untouchability, if you do not mingle with every member of the society, then what will happen, that you can be punished. So, that was the time, might be the time of inequality. You might have heard that even in western countries before 18th, 19th century, there was the practice of slavery. So, you see those times were the times of inequality, and perhaps there might be some rules on that, but we are not satisfied with these rules. Finally, we will move on to some rules about punishment, and he said we will just look at some of these provisions. Like he said that without considering the facts and laws regarding the dispute, there should not be any punishment. And he said that Dandasya hi bhayat sarvam jagad bhogaya kalpate, means dand, the role of punishment, is very important. Further, he talks about punishment for gambling. Further, he says that smuggling is prohibited and smuggling may be punishable with death also. He says dacoity was punishable with death. And then very importantly, you see in those times also the importance of saving the environment, not littering on the roads or on the pavements. In those times he very interestingly laid down the rule that littering is a crime and that will be punishable with fine. So that was a very interesting thing in those times, that littering was not allowed. You can't make any place unclean. Seller selling less quantity of goods or of inferior quality. You remember Sale of Goods Act? In Sale of Goods Act of our times, there is such a rule. So seller selling less quantity of goods or of inferior quality, that will also be punishable. So you see that in those times, this lawgiver, this sage who gave lot of laws, lot of rules, he laid down a new kind of jurisprudence which can be an amalgamation of positive, but it was majorly a positivist school itself, where but then not in the strict sense, because the positive school, that they gave lot of power in the hands of the sovereign, but Manu was not giving that much of power to the sovereign. So we have seen today that in this lesson what we have seen, that Manu had given lot of rules. Manu laid down a new jurisprudence in those times 2000 years back, and some of those things are still relevant, but some of the things which he said are not relevant, because now we have our constitution, which is the highest law of our country. So if there will be a conflict of any provision with our constitution, then or the laws which are made by the parliament, then what will prevail? The laws will prevail, the constitution will prevail. So I hope that you must have understood today's lesson. I thank you so much for giving your kind attention. Have a great day. Thank you.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar, and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.